Good afternoon. This is Jennifer Carroll here with another edition of Florida Appeals Journal. Today we're going to talk about venue. I had a case come out recently that addressed this very important procedural issue, and I think it's worth taking a look at. Gives a good understanding of how venue works. And in this case, it was a probate case, but how it should work in Florida. This case, and it's just got the Westlaw site, it's the Marks case, Markes, 2025 Westlaw 1242092, and that's 4th DCA, April 30th, 2025. And that case, you had a legal battle about where to handle a parent's estate. Some of the children filed the probate action in Broward County. Another child argued the case should be moved to another state, namely New York. So how do you decide where probate should be? I mean, you had the probate estate was open down here, the decedent owned property in Florida, and still there was a big fight about, well, where is he domiciled? Decedent has to be domiciled where the estate is open, but not necessarily. Okay. Domicile, and that's another topic probably for another day, but basically it's wherever the decedent intends his residence to be. So intention, and that's a heavy fact question, but there's a big fight about that in this opinion. But this opinion becomes very significant, I think, for other reasons. It really goes beyond that. The decedent wasn't living in Florida when he passed away. But what the court held is, well, you don't have to be living in the state, okay? What is important is, do you own real estate in the state? And in this case, the decedent did own real estate. And with this opinion, the court held that's enough, that Florida would have jurisdiction and could retain jurisdiction to carry out the probate of the estate. Now, a couple of things I want to mention to you is when someone is trying to get involved, if you've got a probate open and you have someone trying to get involved in the estate proceedings, you have issues of if they're an interested person, are they an intervening party? Just remember there's a general proposition that if you're an intervening party in an action and you don't qualify, let's say, as an interested person, and in this case, I believe that the one child did qualify as an interested person. But if you're just intervening, then you really have no say in where that case is going to be litigated, okay? An intervening party just takes the case as he or she finds it, okay? Intervention, when you intervene in a proceeding, you take subordinate. It's really in subordination to the main proceeding. So that's a very significant fact when you're trying to decide who can really challenge certain matters going on in the litigation. Okay. One case I want to mention is Minnick. That's a very old case, 111 Florida, 469, 1933. But that distinguishes domicile between domicile and residence, and you want to be aware of that when you get into this whole issue of residence isn't really a domicile. It becomes a real academic debate, but it emphasizes intent is the main issue to be decided on that. All right, but you can bypass all that. Let's go back and what this court held. And actually, they said, you can go by and start with the statute. 733.101 makes it clear that venue would be proper. And in this case, it would have been Broward County. That states the venue for probate of wills and granting letters of administration, right, shall be in the county in this state where the decedent was domiciled. B, if the decedent has no domicile in this state, then in any county where the decedent's property is located. That's a very simple and very applicable statute to look at first when you're evaluating these types of issues. Now, also, what the court held in the Marks opinion, and this was the main error, is the court held that the trial court had no authority to even transfer the case out of state. So, and that's just something that the law in Florida doesn't allow. So that's in now there's, I think, clarity. I think it makes it clear in Florida law that you can't. The court relied on an older case. I think it was a third DCA case. It's the Rogers case, and that's not too old. 688 Southern Second 421. And that was a case where, just out of the blue, really, the third district said that trial court had absolutely no authority to, quote, transfer the probate proceeding to San Francisco, California. But there's no further explanation that it gives, because as you can imagine, there can be transfers, and I think they even said that you can have transfers. I think in a footnote, we know that you can't say that a trial court can never dismiss an action on the basis of form nonconvenience, for example, or transfer a case, they said, to a different court within the county or to a different county within the state of Florida. And you also have other issues that arise that may justify transferring a case to another state. And I think, if there's a question of if that state had acquired jurisdiction earlier or had some pending matter. But again, a very fact intense and fact sensitive. But I do think this recent case that comes out just point blank just says, hey, Florida courts, you can't transfer a probate case to another state. I think they actually make some law there in the case. So I would recommend, if you have this issue arise with respect to venue and where to be litigating the probate case, I would recommend you take a look at the Marks case. As usual, any questions, let us know. Thank you again. Hi, I'm Jennifer Carroll, and I want to thank you for watching our video. You can see more of our videos right here. Or better yet, subscribe to our YouTube channel below so you won't miss a single one.